I'm here with Fred Kate, Distinguished Professor of Law at the Maurer School of Law, Indiana University, Bloomington. And I know, Fred, you have many other titles and accolades, but the one that caught my eye is that you were affiliated with SIPL as a senior policy advisor, correct?
You are absolutely right. I'm for a very happy time.
Okay. Well, I thank you very much for joining us today. And as you know, we're here to talk about the leaked draft opinion from the U.S. Supreme Court that has generated very impassioned, sometimes heated and vitriolic reactions, which is something we don't ordinarily see in the privacy space. Even though we may get excited about privacy issues, usually other people don't, and it certainly doesn't make the evening news. But we, of course, today are talking about the Dobbs versus Jackson Women's Healthcare decision, which, according to the draft opinion, would overturn Roe v. Wade, which held that the U.S. Constitution confers a right to an abortion. So given that topic and the reactions that it invokes, we thought it would be a good idea to give SIPL members a sober analysis of the scope and the likely effects of the ruling, if it does turn out to be the one that the court issues. So we called on you, Fred, to do just that. Thank you. So first off, can you give our audience what the underlying dispute is all about and what Alito is proposing to be the specific holding in this case?
Sure, thank you. So Dobbs versus Jackson was leaked on May 2nd, and it deals with a law in the state of Mississippi that would ban abortion after 15 weeks. And this would be a significant move back from the 24-week rule that we generally apply in the United States. But in doing that, the draft opinion, and I hesitate, I repeat, it is a draft opinion. So we don't know if this is what the court's going to actually do. But right now, the draft we have says that they're not just going to say, okay, we'll go back to 15 weeks. They're actually going to overturn Roe versus Wade, which was decided in 1973. So we're almost at its 50-year anniversary, and first established the right of a woman to make a choice about whether to carry a fetus to term, subject to some state limitations. So it recognized there were legal rights on both sides of that equation.
Okay, so Alito's opinion is going to the substance, I guess, of the Mississippi law, but to get to it, he has to do what?
Right. So I think what has upset the privacy community a lot, and it has been upset. It's funny. I was reminded early on in the dispute, the president of the United States came out and said this threatens privacy, and then almost the same day, the IAPP president, Trevor Hughes, came out with this quote. Privacy pros should be clear on this point. The leak decision, if it stands, is a privacy decision. Rolling back 50 years of jurisprudence on privacy rights is, in a word, shocking, close quote. So the question is it really doing all that?
Yeah, would Alito agree with that?
Alito would not agree with that. But I think there's room to see both sides here. So there's no right to privacy in the U.S. Constitution explicitly. The word's never actually used in the U.S. Constitution. So there are various rights to privacy courts have identified. For example, the right to be free from certain searches and seizures by the government, or the right not to have soldiers quartered in your home. That's thought to be a privacy right. But in a series of cases that didn't actually begin with Roe, but Roe is the most famous of them, the Supreme Court started outlining a sort of notion of a right to privacy that was based on the due process clause of the 5th and 14th Amendments. And that due process clause recognized that you can't infringe upon life, liberty, or property without due process of law. And so what the court said in this case, this line of cases, began in 1965 with Griswold versus Connecticut, which dealt with the right to use contraception. But again, we all know it from Roe in 1973, is that there's a zone of privacy. There's an implicit notion of privacy reflected in the US Constitution. And for a state to ban abortion violated that right to privacy. And just like for a state to not let you use contraception, for a state to not let you marry who you choose, just like for a state to not let you choose where to send your kids, these are all these what we call decisional privacy cases. They're not information privacy. So they're not about the right to keep secret information about you. They're about the right of people to make certain decisions. So in this most recent leaked draft opinion from May 2nd, what the court said is, we just don't see that there. When we look at the Constitution, we don't see that that is actually reflected in the Constitution. So the court said, again, in a draft opinion, we don't know what the final one's going to say, that if the right wasn't widespread at the time the Constitution was drafted, so more than 200 years ago, and it's not specified explicitly, if it's not, in the words of the court, deeply rooted in the nation's history and tradition, and implicit in the concept of ordered liberty, those are the court's words, then we're not going to say it's there. Well, abortion seems to not fit that definition. It wasn't deeply rooted in the nation's history and tradition, at least in the court's view. The challenge is neither was contraception, neither was that you could marry anyone of either sex. Neither were other rights that we have subsequently recognized as justified by the right to privacy. So that's what's got people nervous, is if you say it has to be in the Constitution or it has to be deeply rooted in the nation's history, then you're taking away kind of almost all of modern privacy law. Now, I should say Justice Alito in his draft went out of his way to say, don't worry about that. That's not what we're doing. And his point was pretty straightforward, which is actually only abortion deals with the balance between whatever rights may exist for the decision maker and the taking of a life, as he put it. And so these other issues don't. So where to send your kids to school, who to marry, whatever, these don't have a competing life on the other side. And so what Justice Alito really tried to say is, don't worry about this, though, all of you who are worrying, because only abortion presents this challenge of the balancing it with a living life.
Yeah, he definitely went out of his way to stress that point
repeatedly. And the problem, of course, is that cynics or critics have said, that may be true, but the logic of what the court did to say, look, if it wasn't widespread at the time the Constitution was adopted and it's not explicit in the Constitution, then we're not going to recognize it. That same logic would apply to all of these other rights we were just talking about, all of these other decisional privacy rights.
Yeah, if they are challenged.
Exactly.
Right. But of course, if people are looking for a right to abortion within the Constitution, there are constitutional means to do that, right, with the amendment process. Correct.
Right. And, frankly, people on both sides of the abortion debate, including, the renowned and now deceased Justice Ginsburg, noted Roe is not really well written. It's not well argued. It was an effort by the court to do something the court thought was important. And of course, we've relied on it for 49 years now, but it's a little hard to defend it on its logic. So on the one hand, we've got this kind of tension. So what the Alito draft is doing is not actually shocking from a jurisprudential point of view. It's more shocking from an operational point of view, like the thought that women in the United States would not have this right linked to privacy when women in so much of the rest of the world are now getting that right for the first time.
Yeah. It's, I don't know if ironic is the right word, but Alito did rely a lot on Justice Ginsburg's opinion in Glucksberg, I believe, Washington v. Glucksberg, which was the assisted suicide case, where she wrote about the two conditions that you referred to, about any right must be deeply rooted in the nation's history and implicit in the concept of ordered liberty. So he was relying a lot on Justice Ginsburg for that. But speaking of Justice Ginsburg and a lot of what's recently in the news with the justices themselves being the subject of protests and stuff, that also crosses the privacy line as well, a privacy threshold. So wondering your thoughts on that with the right of judges or justices to have privacy of their home addresses or what have you.
Right. So it's been a very controversial issue in the United States. It's only getting more controversial, which is, we have a pretty robust public record system. And if you buy or sell property or things like that, you're part of a public record. And so it's actually pretty easy to not merely find out where a judge or a justice lives, but you can actually see what their house looks like. You can find out what it's worth. You can find out how it's been valued. You can, when it was last sold, there are lots of things you can find out about it. And historically, we have held that under the Constitution, under the First Amendment to the Constitution, the free speech provisions, that it's permissible to protest anywhere on public property or public right-of-way, provided you don't disrupt the right-of-way, like you can't block a street, and provided you do so peacefully. You can't throw rocks. So if I'm standing on the sidewalk in front of a justice's house, that's actually lawful in this country. And so we have seen protests now, which are not a common thing around the homes of Supreme Court justices, but we've seen them start occurring around the homes of justices. And then you may have noticed, we just saw somebody arrested yesterday for making a threat and in fact carrying a firearm in the presence of Justice Kavanaugh. And that was viewed as posing a true threat, way beyond just the right to protest freely. So what judges at the state level and federal level and justices at the Supreme Court have been arguing for is maybe they should have some ability to keep their information about their kids and their homes and things like that private. And it's actually kind of ironic in a way that on the one hand, we're seeing some pressure on the constitutional right to at least decisional privacy. But on the other hand, we're seeing kind of, again, this practical surge in state legislators, state legislatures, and of course in European and other countries. And now among judges and justices saying, well, maybe there should be more protection for some sort of information privacy. Something the Constitution has only once ever been found to have. And in that case, a case called Whalen, the Supreme Court found a right to informational privacy, but then refused to strike down the restriction at issue there. And so we're in this kind of, I think you used the word earlier, ironic moment. When on the one hand, privacy is getting more important in all of our lives because of digital technologies and the amount of data we generate and so forth. And on the other hand, a little bit of concern about how much privacy should certain people get, in this case, justices of the U.S. Supreme Court.
Yeah, there's also been some commentary, some folks urging Google and companies like that to stop collecting user location data for fear that that could be used to track those who are procuring abortions or those who are performing abortions. What's your response to those concerns?
Well, let me say first, I think lots of companies are going to face this issue. In other words, the more that states can now have abortion prohibitive or abortion restrictive laws, we're going to see more demands for information from the private sector about help enforcing those laws. And so the private sector already has gotten requests, about drugs that are sold to people, which could be used as that cause a biochemical induced abortion, about information about people who visit clinics, and if they're underage, did you have the parents' consent, and very sensitive information. And we're only going to see more of it. So 2/3 of the United States is going to have laws now, assuming that what is the draft opinion becomes a real majority opinion. 2/3 of the United States is going to have laws that are going to empower prosecutors or citizens or somebody to bring cases. And so we're going to see prosecutors and police and courts and others asking for this information. Now, the question you raise is, well, if I don't have the information, I can't provide it. And I think that is true, but you're not going to go very far, because there are also a lot of legitimate uses for the information. So you may use location information to know where your kids are, or you may use location information if you own a fleet of trucks to know where your vehicles are, or you may use this information for billing purposes, or you may use it for other purposes that are valuable and that people care about. There's a reason people turn on location services on their phones, because we like to be able to look at the map and know where I'm standing when I look at the map. And so I think the notion of saying because of a perhaps decreased protection or eliminated protection for the right to abortion, that we're going to see more businesses stop collecting data probably ignores the fact that there are other very valuable, legitimate uses for those data, and that frankly, people want those data to be accessible, at least to them. So then the question is, do I just say I'll collect them, but I won't give them to anybody else? Well, again, if a court issues a subpoena, you're pretty much going to have to give them. I mean, you can resist the subpoena, you can go to court, you can argue about it, but it's rare that you actually get to hold on to the data if you got them and you use them for one purpose.
Yeah. Okay. Well, correct me if I'm wrong, but I believe that the statute at issue in this case, at least, is not a criminal statute, and that the woman who procures an abortion is not fined or sanctioned in any such way. It has to do with the doctor or the provider who may lose a medical license or get it suspended. But it's always
right. But there are a lot of other laws. Many states, a third of states, have laws already on the books that, if Roe is overturned, automatically come into effect. They don't require the signature of the governor. They don't require anything else to be done. They're already just hovering and waiting to take effect. And then, of course, we see laws like in Texas, where anybody can bring a case against the parties involved. And we see laws that have been proposed or enacted in other, particularly Midwestern states, I regret to say, that would criminalize anybody who aids in somebody obtaining an abortion, including driving them out of state to obtain it in another state. So again, we're going to see, I think, a lot of demands for data, whether they come about in civil cases or criminal cases. And industry is going to face this challenge of if we have the data, do we have to supply it?
Right. Yeah, it's good you raised that now the court, if this becomes the actual opinion, will be sending the issue back to state legislators. So it's not outlawing abortion, but it's just going to be a state-by-state issue from now on.
And I'm so glad you said that, Mark, because it's really important. It's something we often leave out in these debates. Constitutional rights are basically negative. They restrain something. They don't grant you an affirmative right. So, like we talk about free speech, but the Constitution doesn't guarantee you free speech. It stops states and the federal government from restricting your speech. So similarly, if Roe is struck down, which it looks right now like it's going to be, it doesn't outlaw abortion. It just says to states, you can now enact laws. The restraint is removed. Then those laws will have to either be enacted or some of them will take effect automatically. They'll have to be enforced. Then they'll be challenged on other grounds. Maybe grounds that they're being enforced unequally, or grounds of prosecutorial overreach, or there are lots of other things. You don't have to always go for a constitutional right when you challenge a law. So I think the one thing we know is this is not going to be resolved anytime soon. This is not, even if we see what will be a very dramatic thing in the United States, the overruling of Roe versus Wade, there'll still be states where abortions are being performed. There'll be people moving across borders. There's going to be a lot that still has to be resolved.
Yeah, oh, definitely. This is not the end of the issue. So this also raises a related issue for employees of the Supreme Court itself, right? With the breach of confidentiality with the leak here. So what issues do you see arising there?
Well, I mean, it's actually quite interesting. It's not clear whoever leaked this that they broke the law, but they clearly broke what has been a long-held, deeply valued thing about secrecy around the court. Remember, court proceedings aren't televised. Clerks never release material. Material that go with the justices when they die, they go to the National Archives, and then they can be released a certain number of years, I think 25 years after their death. I mean, there's a whole sort of customary practice around this. And of course, what the Chief Justice said in his statement the day after this leak is he said, yep, this is real. And I'm ordering an investigation right now. So I think we can assume that everyone who works for the court, starting with clerks and staff, but maybe ultimately including justices, is going to have some pretty probing inquiries into their own data about who have they been communicating with, what have they been doing. Again, they're all government employees, so they more or less waive their rights as long as it's not a criminal prosecution involved, as long as it's just an employment action. The government has really broad power to do that. But it's going to be interesting to see whether it provokes a new discussion about privacy as a legal matter for government employees or privacy for clerks in particular.
Very good. Well, I thank you for sharing your thoughts and insights with us today, and hope we can host you again on another topic.
It's been a real pleasure, Mark. Thank you very much.
All right. Bye-bye.
All right. Take care.